Hello, my name is Joseph Martino, Director of the SIU, or Special Investigations Unit. On May 27, 2020, Regis Korchinski-Paquet fell tragically to her death from the balcony of her 24th floor apartment in Toronto. Because Toronto Police Service officers had interacted with her and were present in her apartment at the time of the fall, the SIU was notified and commenced an investigation. The investigation is now concluded. On my review of the evidence, there are no reasonable grounds to believe that any of the officers committed a criminal offense in connection with Ms. Korchinski-Paquet's death. The SIU has notified the family and their representatives of the results of our investigation and the decision, and provided them a copy of our report. The Toronto Police Service and their involved officers have also been notified. The Office of the Attorney General of the province, the Honourable Doug Downey, has been provided a copy of the report. I am here today to personally deliver the results of the SIU's investigation to the public at large. This is not the SIU's ordinary practice. Typically, where no charges are laid, a full report is issued which contains the investigation's findings and reasons for decision. However, the SIU recognizes that this is not an ordinary occasion, given the incredible public interest and attention that this case has generated. Thus, while I refer the public to our website, siu.on.ca, for a copy of the report that has been prepared in this case for a comprehensive and detailed account of our investigation and decision, I would like to personally provide an overview of the report. I would like to begin by thanking the family of Ms. Korchinski-Paquet for their assistance and cooperation with the SIU investigation. Despite their grief at the loss of a loved one, they made themselves available for interviews. Their lawyers, Mr. Singh and Mr. Morton, have been also very helpful, identifying additional witnesses for the SIU and promptly producing the results of a second autopsy. Before turning to a chronological summary of the events of the day, I propose to first address a number of issues. First and foremost, it must be acknowledged that Ms. Korchinski-Paquet's death and others in recent months has raised important issues of social consequence. On the heels of the death of George Floyd at the hands of police in Minneapolis and the protest movement it has spawned across the United States, Canada, and elsewhere, there is increased scrutiny of our society's policing of members of the Indigenous and Black communities. Ms. Korchinski-Paquet was a member of both communities. I accept that systemic racism exists and continues to challenge the relationship between racialized communities and the institutions of our justice system, just as it does in other sectors of society. Our leaders have acknowledged it, as have our laws. As is set out in the preamble of Ontario's Anti-Racism Act, quote, "Systemic racism is a persistent reality in Ontario, preventing many from fully participating in society and denying them equal rights, freedoms, respect, and dignity." However, the task before me was a narrow one, namely, to determine whether there were reasonable grounds on the evidence collected by the SIU to believe that any one or more of the officers who responded to Ms. Korchinski-Paquet's apartment committed a criminal offense in connection with her death. It was not to conduct a broad inquiry into systemic discrimination on the part of the police service. There are other forums with the institutional mandates and expertise to conduct those inquiries. Having said that, the SIU cannot and must not turn a blind eye to issues of race to the extent they are manifest in a specific case under investigation. With respect to the circumstances culminating in Ms. Korchinski-Paquet's death, the investigation turned up no indications of overt racism being brought to bear by any of the involved officers. That is not to suggest that questions of race were entirely absent in the encounter. There is evidence for Ms. Korchinski-Paquet's family that Ms. Korchinski-Paquet attempted to court favor with the police at one point by informing them that her father was coming and that he was white. The officers, it must be noted, did not hear any such utterance, nor were they captured by the wireless microphones worn by two involved officers. Needless to say, if true, the utterance is testament to the importance of efforts to build and nurture trust in the relationship between the police and members of the Black and Indigenous communities. There were allegations in the wake of Ms. Korchinski-Paquet's death that she was pushed off the balcony by the police. The evidence establishes that this did not occur. Instead, the evidence indicates that no one other than Ms. Korchinski-Paquet was on the balcony when she scaled over the railing and attempted to sidestep along the outer ledge over to her neighbor's balcony, lost her balance, and fell. That was the evidence of the subject officer and witness officer number 3, who were present in the apartment at the time, confirmed by the account of civilian witness number 6, a female paramedic who was in the apartment having been brought in to attempt to calm Ms. Korchinski-Paquet. It was also the evidence of civilian witness number 4, an independent civilian witness who was walking on High Park Avenue near the apartment building in question, looked up and saw Ms. Korchinski-Paquet on the outer side of the balcony railing, moving quickly along the railing to her right before she fell. There were also allegations that moments before she fell, Ms. Korchinski-Paquet was heard to repeat, quote, "Help me, Mom," or words to that effect, a few times. The investigation was unable to resolve whether these words were, in fact, said. A civilian witness claimed she heard, quote, "Mom, help! Mom, please help me," several times from a neighboring apartment in the moments before Ms. Korchinski-Paquet's death. However, the security video recording from the apartment building establishes that this witness had left the apartment well before the police arrived. These utterances were also not captured on the wireless microphones worn by 2 officers involved in the incident, although it must be said that the audio recording is not determinative because it cuts out at portions. Moreover, none of the officers who were in the area, including the officer who was in the apartment closest to Ms. Korchinski-Paquet, the subject officer, or civilian witness number 6, the paramedic, indicated that they heard these words spoken. There is indication, however, that Ms. Korchinski-Paquet, while on the phone with her father, did ask him to help her. Turning then to the incident in question. Beginning at about 5:13 p.m., the Toronto Police Service received multiple 911 calls about a domestic disturbance in apartment 2416 at 100 High Park Avenue among the residents of the home, Ms. Korchinski-Paquet and her mother and brother, civilian witnesses number 7 and 2, respectively. Ms. Korchinski-Paquet placed 3 of these calls. Civilian witness number 7 and civilian witness number 2 each made 1. I need not go into detail regarding the content of these calls, as they are summarized in the director's report. Officers were dispatched to the scene at about 5:16 p.m. The subject officer and witness officer number 3 were the first at the apartment, arriving on the 24th floor at about 5:29 p.m. They were met outside the elevators by civilian witness number 7 and Ms. Korchinski-Paquet, who was yelling down the hall toward her apartment. Ms. Korchinski-Paquet told the officers that her brother had assaulted her. At the southern end of the hall was civilian witness number 2. Witness officer number 3 remained with Ms. Korchinski-Paquet as the subject officer accompanied civilian witness number 7 and civilian witness number 2 further south down the hallway and eventually into their apartment. At about this time, witness officer number 2 arrived and joined witness officer number 3 in speaking with Ms. Korchinski-Paquet near the elevators. Ms. Korchinski-Paquet told the officers she had experienced seizures earlier in the day and damaged the television when her brother refused to lower the volume. The subject officer spoke with civilian witness number 2, who confirmed Ms. Korchinski-Paquet's seizures and the argument over the television volume, adding that his sister had grabbed knives from the kitchen. Witness officers number 4 and number 1 were the next 2 officers to arrive on scene at about 5:34 p.m. Seconds later, witness officer number 4, who together with witness officer number 1 had reached the other officers, engaged Ms. Korchinski-Paquet and escorted her further north up the hallway. Ms. Korchinski-Paquet indicated that she needed to urinate and threatened to relieve herself in the corridor if she was not permitted back into the apartment. The subject officer agreed and accompanied Ms. Korchinski-Paquet inside the apartment, as did witness officer number 3 a short time later. The time was about 5:35 p.m. Also at about 5:35 p.m., paramedics, civilian witnesses number 6 and 5, arrived on the 24th floor with a stretcher and made their way south down the hallway. Ms. Korchinski-Paquet had called her father, civilian witness number 1, inside the bathroom of her apartment and was still on the call when she exited. Civilian witness number 7 entered the apartment at about 5:37 p.m., and she and Ms. Korchinski-Paquet argued with each other. About 20 seconds later, civilian witness number 6, the female paramedic, entered the apartment. The subject officer attempted to persuade Ms. Korchinski-Paquet to speak with the paramedic, given her seizures earlier in the day. Civilian witness number 7 exited the apartment into the hallway at about 5:38 p.m. Within seconds of her departure, witness officers number 1, 2, and 4 entered through the apartment door. Ms. Korchinski-Paquet refused to speak with civilian witness number 6. Instead, she backed away from the officers, toppled a stand-up portable air conditioning unit by the balcony door and exited through the door onto the balcony. Civilian witness number 7, Ms. Korchinski-Paquet's mother, entered the apartment again at this time, followed by civilian witness number 2, Ms. Korchinski-Paquet's brother. The subject officer told Ms. Korchinski-Paquet to re-enter and attempted to open the door, a hinged screen door that opened onto the balcony. But Ms. Korchinski-Paquet kept it closed using her body weight. Very quickly, Ms. Korchinski-Paquet scaled the balcony railing and the subject officer lost sight of her. At about this time, civilian witness number 7 asked, quote, "What is she doing?" A male voice replied, quote, "She's going to the neighbors." Witness officer number 1 said, quote, "She's jumping balconies." Civilian witness number 7 indicated, quote, "She can't get to the neighbors," followed shortly by civilian witness number 2 saying, "It's blocked off." Believing Ms. Korchinski-Paquet was attempting to cross over to the neighboring balcony to the north, witness officer number 3 reported this information over the radio. The time was about 5:39 p.m. At word that Ms. Korchinski-Paquet was on the balcony crossing over to an adjacent balcony, witness officer number 4 directed everyone out. He and another officer knocked on the front door of the adjacent apartment, but received no answer. Witness officer number 4 returned to Ms. Korchinski-Paquet's apartment and made his way onto the balcony, where he noticed a metal partition dividing the adjoining balconies with denning completely around the balcony to the north, making it inaccessible from the outside. Believing Ms. Korchinski-Paquet had nowhere to go, he looked down and saw her body on the ground below. Ms. Korchinski-Paquet was pronounced deceased at the scene at 6:05 p.m. A post-mortem examination was conducted on May 28, 2020 at the facilities of the Provincial Forensics Pathology Unit in Toronto. By way of report dated June 15, 2020, the pathologist attributed Ms. Korchinski-Paquet's death to, quote, multiple blunt impact trauma, which were consistent with a fall from a height. That conclusion was confirmed in a second autopsy conducted by the Office of the Chief Medical Examiner for Newfoundland and Labrador at the request of the family. There are two theories which present themselves for consideration as far as the officer's potential criminal liability is concerned in relation to the events culminating in Ms. Korchinski-Paquet's death. The first asks whether the officers went too far in the exercise of their authority. The second, whether the officers went far enough. First, did the officers overstep their authority? Having personally heard the 911 calls to police and reviewed the transcripts of those calls, I am satisfied that the officers who responded to Ms. Korchinski-Paquet's apartment were there lawfully. As far as they knew, they were responding to multiple reports of assault, some which claimed Ms. Korchinski-Paquet had attacked her brother, others indicating that Ms. Korchinski-Paquet had been attacked by her brother and or mother, all of which mentioned the presence of knives in the course of the altercation or altercations. At one point, after the subject officer had finished speaking with civilian witness number 2 inside the apartment to get his side of the story, he stepped into the hallway intending to speak with Ms. Korchinski-Paquet. Ms. Korchinski-Paquet yelled at civilian witness number 2 and tried to approach him. The subject officer used his body to block her path, and Ms. Korchinski-Paquet backed down. This constituted a measure of force on the part of the officer, but one which I am satisfied was reasonably necessary in the circumstances. The subject officer was within his rights in attempting to preserve the peace and prevent a further altercation between the siblings, and he did so with minimal force and without injury. To her credit, Ms. Korchinski-Paquet did not press the issue, and tensions abated, but only momentarily. Aside from the physical force used to keep Ms. Korchinski-Paquet away from civilian witness number 2, it is also true that the officers exercised non-physical control over the movements of Ms. Korchinski-Paquet, civilian witness number 7, and civilian witness number 2 upon their arrival on the 24th floor, deciding, for example, who would and would not enter the apartment at times during their interaction. Thus, for example, when Ms. Korchinski-Paquet entered the apartment to use the bathroom, steps were initially taken to keep civilian witnesses number 2 and 7 in the stairwell. I do not believe the officer's conduct in this regard was unlawful. More specifically, I am satisfied that Ms. Korchinski-Paquet, civilian witness number 7, and civilian witness number 2 were under lawful detention at the time. In R.V. Mann, the Supreme Court of Canada confirmed that a police officer has a limited power to detain an individual for investigative purposes if the officer has a reasonable suspicion that the person is connected to a crime. In the instant case, the officers were aware, via the information that came in on the 911 calls, that they were responding to deal with an assault that had involved physical violence and weapons. On their arrival at the scene, the broken glass on the hallway floor and the enmity on display between the family members would have reinforced the notion that an unlawful assault had occurred. While knives were not present in the hallway, their presence in the apartment had yet to be ruled out by the officers. On this record, it would seem the officers had a lawful basis to temporarily detain Ms. Korchinski-Paquet and her family, and to control their access to the apartment, while they tried to figure out whom among them were the victims and whom among them were the perpetrators of the reported assaults. The issue turns to whether the officers could have done more to prevent Ms. Korchinski-Paquet's death, and if so, whether their failure to do so amounted to a criminal offense. There are two offenses that arise for consideration on this theory of liability, namely, failure to provide the necessaries of life and criminal negligence causing death, contrary to sections 215 and 220 of the Criminal Code, respectively. I deal first with the former. The offense is premised in part on conduct that amounts to a marked departure from the level of care that a reasonable person would have exercised in the circumstances. In the instant case, the liability analysis boils down to the following question. Ought the officers have apprehended Ms. Korchinski-Paquet at some point before she scaled the balcony railing? While there were grounds for Ms. Korchinski-Paquet's detention, I am not satisfied there was a lawful basis to assume complete control over Ms. Korchinski-Paquet's movements via an arrest. The officers had conflicting information about who had done what to whom, and were still attempting to sort that out when Ms. Korchinski-Paquet took the drastic action she did. Was there some other basis upon which the officers could have acted? Section 17 of the Mental Health Act provides, in part, that police officers may take a person into custody for psychiatric examination at hospital, where they have sufficient grounds to believe the person is acting or has acted in a disorderly manner, at risk of self-harming or harming another person, and suffering from a mental disorder that will likely result in serious harm to the person or another person. It appears that some of the officers who responded to the scene turned their minds to whether the Mental Health Act was applicable to the situation at hand. One of them, at least, witness officer number 4, seems to have concluded it was not. Informed by civilian witness number 7 outside the apartment that Ms. Korchinski-Paquet suffered from seizures, the officer asked, quote, "What about mental health?" I am not a doctor, nor versed in the medical community's modern-day understanding of epilepsy and the seizures it produces. The limited layperson's research I have conducted of the matter suggests that epilepsy is a neurological disorder with manifestations that can be mental as well as physical. Be that as it may, I cannot fault the officers for failing to take Ms. Korchinski-Paquet into custody prior to her scaling the balcony railing. She had not given them any indication that she wished to harm herself, and was professing to be the victim of an assault at the hands of her brother. There is no doubt she was irate, and perhaps even behaving in a disorderly manner in the presence of the police, but that would not have been unusual for a person claiming to have been assaulted and demanding the police take action. Separate and apart from whether Ms. Korchinski-Paquet was suffering from a mental disorder, therefore, I am unable to reasonably conclude that the officers were derelict in failing to apprehend Ms. Korchinski-Paquet under the Mental Health Act, at least until such time as they were satisfied that she was the aggressor of the violence that had preceded their arrival, or at risk of self-harm. I am satisfied they never reached those conclusions, nor were there necessarily grounds for having done so. For the foregoing reasons, there are no reasonable grounds, in my view, to believe that the officer's failure to take Ms. Korchinski-Paquet into custody for her own protection amounted to an offense under Section 215 of the Criminal Code. The liability analysis turns to whether there is evidence of criminal negligence against any one or more of the involved officers. The want of care at the heart of criminal negligence causing death is more egregious than that which defines other species of negligent-type criminal offenses, such as the failure to provide the necessaries of life under Section 215 of the Code. The latter are premised on a marked departure from a reasonable standard of care. The former is not made out unless the impugned conduct amounts to a marked and substantial departure from a reasonable standard of care. Regardless of the officer's understanding of epilepsy or the precise nature of Ms. Korchinski-Paquet's mental health at the time, it was obvious that they were responding to a family dispute in which emotions were heated. Once the parties had been duly separated to prevent a continuation of further hostilities, de-escalation efforts would have been in order. The evidence indicates that the officers made efforts to defuse the situation. For example, once Ms. Korchinski-Paquet was inside the apartment with the subject officer, and after the officer had been unable to establish any productive communication with her as she emerged from the bathroom on the phone with her father, civilian witness number 6, the female paramedic on scene, was brought in. As witness officer number 1 explained, paramedics had, in her experience, been effective in de-escalating situations in which individuals had not reacted well to police presence. Unfortunately, civilian witness number 6 could make no inroads. The weight of the evidence, including the video recordings of the corridor and the audio recordings of dialogue at the scene captured by the wireless microphones of witness officers number 4 and number 1, also suggests that the officers were not aggressive in their dealings with the family. The family has raised objections with the number of officers who arrived on scene, 6, and with the long gun in the possession of witness officer number 4. However, the officers were responding to an assault call involving multiple parties and the use of knives. It should also be noted that the weapon carried by witness officer number 4 was a soft gun, also known as a beanbag gun, which was loaded with less lethal rounds. In the circumstances, I am unable to characterize the nature and extent of the police resources deployed as an overreaction or heavy-handed. There remains the question of the TPS Mobile Crisis Intervention Team, or MCIT. The teams bring together officers specifically trained in de-escalation techniques with mental health nurses to rapidly respond to situations involving, quote, emotionally disturbed persons. Whether Ms. Korchinski-Paquet was in a mental health crisis, strictly speaking, she was certainly emotionally disturbed, in the language of the TPS MCIT policy, and might have benefited from the expertise brought to bear by the MCIT. However, the policy expressly precludes the deployment of the MCIT as first responders with respect to incidents involving the possible use of weapons. This was such a case. Finally, the decision to disengage soon after Ms. Korchinski-Paquet moved to the balcony and scaled the railing is open to legitimate scrutiny. The decision to do so was made by witness officer number 4 and followed an initial attempt on the part of the subject officer to enter onto the balcony after Ms. Korchinski-Paquet. Arguably, the situation called for a more proactive posture at that moment, one in which, perhaps, officers entered onto the balcony to try to coax or physically pluck Ms. Korchinski-Paquet back to safety. As it turned out, within seconds of scaling the railing and attempting to make her way over to the neighboring balcony, Ms. Korchinski-Paquet lost her balance and fell. On the other hand, Ms. Korchinski-Paquet had given the officers no reason to believe that she was intent on harming herself. Instead, as they correctly surmised, she was attempting to traverse to the neighboring balcony. In their SIU interviews, some officers indicated withdrawal was pursued so as not to do anything that could startle or further provoke Ms. Korchinski-Paquet, who was at the time in a very precarious position, perched on a narrow ledge on the outer aspect of the balcony railing, 24 stories in the air. In his SIU interview, witness officer number 4 noted that he had previously spent 3 years in the MCIT. It was his judgment at the time that the officer's best recourse was to have the emergency task force dispatched to a situation that had suddenly become life and death. Certainly, the ETF is trained for these sorts of high-risk incidents and would have been able to bring to bear resources to attempt a rescue operation that the officers on scene were without. In this context, if the officers fell short in their decision, I am satisfied the decision was not one divorced of logic. In the final analysis, I am satisfied on the totality of the evidence that the conduct of the officers who responded to Ms. Korchinski-Paquet's residence did not amount to a marked and substantial departure from a reasonable level of care in the circumstances. In conclusion, as I was satisfied that the involved officers acted lawfully throughout their engagement with Ms. Korchinski-Paquet and her family, there were no grounds for proceeding with criminal charges in this case, notwithstanding Ms. Korchinski-Paquet's tragic death.